Dr O'Sullivan QC graduated with Bachelor of Arts and Bachelor of Laws, first class honours both, from the University of Queensland in 1993 and 1994 respectively. He was admitted as a solicitor with the well-known Brisbane firm Fays Roofing, and after that undertook postgraduate study at Exeter College in Oxford as a Commonwealth Scholar, obtaining his DPhil in 2001. He practiced as a member of chambers in London from 2001 to 2006, where he remains an associate member, and since 2006 he's practiced at the Queensland Bar. He was appointed Queen's Counsel in 2014. Now, I've had the advantage of glancing at the paper, and as you would expect, it is a work of scholarship, and I'm sure that you will all find it interesting and educational. Could you please welcome our speaker?
Thanks very much, Justice Fraser, and thank you all very much for coming this evening. We've certainly got some Scottish weather outside. By selecting leading English judges from the Elizabethan era down to today, this series of lectures, of which tonight is a part, seeks to tell us something about the lives of important judicial figures, and at the same time, something about the times in which they lived and worked. So far in the series, we've heard of the great Edward Coke, who lived in the late 16th and early 17th century. We've heard of Lord Mansfield and Lord Eldon, who are either end of the 18th century. And tonight, we're going to move forward into the 19th century. And we'll discuss the most important judge of the Victorian era, the remarkable Lord Blackburn. He was an unknown Scots barrister when he was appointed to the surprise of the profession to the Court of Queen's Bench. And after that, he went on to establish himself as the greatest common law judge of the century. He's said to have made a larger contribution to the development of English law than any other judge since Lord Mansfield, and indeed of any English judge, save for Mansfield. And among these contributions, it's been asserted by scholars that he introduced into English law the doctrines of mistake and frustration in the law of contract. So Blackburn is interesting to us not only because we can see that he dominated the 19th century, but he's interesting also because of the lasting contribution he made to English law and thereby, of course, to Australian law. So my plan tonight is to proceed chronologically through Lord Blackburn's life. And in doing that, I want to try and develop three points, and at the same time I want to try and give you some picture of legal life in Victorian England. So the 3 points. The first is we want to explore the curious fact that although he became enormously important as a judge, Lord Blackburn was not indeed a successful barrister at all. And we'll look at why that might have been so, and spend a moment also reviewing the reasons for the furore that erupted when he was appointed a judge in 1859, the same year, coincidentally, when Queensland was created as a separate colony. The chronology in the handout will give us an overview of his life, and you'll see 1859 is an important date. The second point I'll seek to develop during the lecture is the interesting disconnect, I think, between, on the one hand, those cases that drew Lord Blackburn to the attention of the Victorian public and indeed to lawyers on the one hand, and on the other hand, the cases that he's now regarded as being responsible for in the development of our law. This disconnect between what was important at the time and what we regard as important now. None of the cases that we now regard as foundational to the common law were at the time seem to attract much attention at all. So that's the second point. The third point we'll try and make in this address is that we'll try and make the point that Lord Blackburn's importance today is not merely, or indeed principally, a function of his peculiar genius as a judge, although certainly he was a remarkable man. I'll try and explain briefly why the location in time of Lord Blackburn, the time that he was writing, was probably more important to his lasting significance than his peculiar qualities as a judge. And I think the last point is particularly interesting to us, anyone interested in legal history, because we'll remember that the royal courts date from the 13th century, and so it therefore took 600 years of history before the contours of private law that are familiar to us today, the division between contract, tort, and unjust enrichment, those contours didn't emerge for 600 years, and then in the 19th century we saw for the first time this great division coming into being. So to my mind, the importance of the Victorian era justifies Fivefoot's observation, which he made back in 1959, giving the 11th Hamlin lecture about the Victorian era, when Fivefoot said this of that era, and I quote, he said, "To recall the judges and jurists of the 19th century may provide an anecdote to the most vulgar and provincial of modern heresies, the indifference or contempt for any age but one's own, the impudent assumption that the world belongs to the living and is a property in which the dead hold no shares." We turn then to Colin Blackburn's beginnings, a man who we might probably say certainly has a great deal of shares in the present. His father was John of Glasgow. He left Scotland as a young man at about the age of 16 and he sailed to Jamaica. He didn't come back to Scotland until he was much later in life, and it appears that in Jamaica John made a fortune. We don't know how, but probably in sugar. We'll come back to Jamaica in a minute. It features, strangely enough, in Blackburn's career. After John Blackburn married Rebecca Gillies, their son Colin was born in 1813 in Dunbartonshire in Scotland. He was the second of 8 children. His early childhood we know not very much about. It was probably lived at Killian House, which was a stately mansion sitting in beautiful countryside north of Glasgow in the valley of the River Blaine. He was sent away to be educated first at Edinburgh Academy, then at Eton College before going on to Trinity College, Cambridge. He's said to have been a very serious student at Cambridge. He studied mathematics rather than classics, and he matriculated in 1835 Bachelor of Arts as something called 8th Wrangler. To Victorians this meant a lot if you were a high wrangler. It meant that he was placed 8th in the group who obtained a first class degree, so he was 8th. And at the time, if you were a high wrangler, that was regarded as a mark of high distinction, fitting a young man for a career in the law. Colin Blackburn was admitted after that as a student of Lincoln's Inn in 1835. We might pause here to note that at this time, the universities in England offered no degree in law, nor indeed did the Inns of Court provide the training to lawyers they once had many hundreds of years before. So it wasn't until 1852 that the court adopted a scheme of legal education. The Inns of Court adopted this scheme, but it was said to be, I quote, supine or ineffectual, whilst in 1851 the Convocation at Oxford established the first serious examination for the Bachelor of Civil Laws. It seemed to be no more than an hour's disquisition upon obscure points of Roman law, in Latin of course. And a separate school of jurisprudence wasn't established in Oxford until 1871, and even that had no focus on contemporary law. Across at Cambridge, an LLB degree was set up in 1854, but there didn't seem to be a great deal of take-up for that degree, and one reason was that one didn't need a degree to enter the Inns of Court. So there was not really any degree for Colin Blackburn or his contemporaries. There are also almost no legal books. Fivefoot says, and I quote, "Save for Blackstone, there were few books which an intelligent mind above drudgery could attempt to read without dismay or disgust." Now, notwithstanding the intricate complexities of the rules that attended pleading and practice before the 1852 reforms, Colin Blackburn was therefore to learn the common law in the tried and tested means of the time. And he did this. He became a pupil. He became a pupil to a conveyancer, special pleader or equity draftsman for 2 years in a process that Lord Campbell described as pupilising, and which did little more than prepare the young lawyer to learn his trade and practice. Of this system of legal education, Lord Selborne, the great reformer, later said, he said this, "Having thus reared a superstructure without foundations, all that could be done afterwards was to underpin it, an operation not more satisfactory or safe in education than in building." Apparently Blackburn found pupillage. I don't know, I've been unable to discover who his pupil masters were. He appears to have spent 2.5 years as a student before, in November 1838, he was called to the bar by the Inner Temple. And at that point, the young 25-year-old barrister was ready to start his new career as a new career at the bar. Now, what happened next matched the experience of most barristers starting out in practice in the 1830s and 1840s. The man who had later become the greatest common law judge of the century obtained almost no work at all. The entry for him in the Dictionary of National Biography, which was published in 1901, described his early career in the following words, I quote, "For some years after his call, he went on the Northern Circuit in a briefless or almost briefless condition. He had no professional connection, no turn for politics, no political interest, none of the advantages of person and address which make for success in advocacy." We'll come back to some of those statements about what he was missing in a moment. Blackburn's early years were very typical of the times. There existed, it seems, a great imbalance between the number of barristers and the amount of work to be done. The formal requirements for admission, as we noticed earlier, to an Inn of Court were very limited. It was said that to qualify for the bar, a man, I quote, should eat and drink and be able to write his name. There was not nearly enough work to go around, particularly for juniors, and practically all those who rose to prominence later at this time experienced early years with little or no work and a great uncertainty about whether they would ever obtain any. The young barristers typically would survive on parental allowances or writing for journals or law reporting while they struggled to become recognised. I don't know, but I infer that his father must have provided the means for Blackburn to support himself. He certainly was not making any money from practice. His contemporary Alexander Cockburn, later Chief Justice of the Court of Queen's Bench in Blackburn's time, a far more connected Scotsman than Blackburn, from a very ancient family, his early years were said to have been marked, I quote, with struggles in which was mingled no small dash of adventure as he made his escape from his creditors. He later became the Chief Justice of the Court of Queen's Bench. Now, as we've seen, Blackburn was the studious son of a Glasgow sugar merchant. He had no political connections, no social connections of a kind that his contemporaries could have pressed into service to generate work. In addition, it seems that Lord Blackburn's personal qualities, as we saw a moment ago, made him somewhat unsuited to the work of a barrister in the 1840s and 1850s. Sergeant Ballantyne, who was a contemporary of Blackburn, who fortunately for us wrote some memoirs of his time, he said as follows, and I quote, "A Scotch accent does not improve a naturally harsh voice, and his demeanour can scarcely be termed graceful or his manner pleasant." Jones reports, and I quote, "His appearance with his burly figure, strong face and round bullet head was not prepossessing." And at a time when the revelry of Haymarket exercised a well-publicised pull for the barristers of the Inns of Court, and many successful barristers were larger-than-life figures in society, it was said of Blackburn that he studied human nature in Cook upon Littleton without assistance of haunts of revelry. Now, this combination ill-fitted Blackburn for the work of a trial barrister. The jury remained a feature of practically all civil litigation at this time, and the successful advocate had to be able to appeal to a jury, men and women, mainly men, from a walk of society which Poll and Blackburn probably had very limited exposure to. An advocate of this time was expected to employ a mix of hyperbole and theatre, and that was regarded as part of his art. Indeed, at this time, the royal courts were regarded as a well-accepted source of entertainment. Those manning the doors would typically charge a fee for entry into the court, and the public would expect and receive entertainment from counsel's address to the jury, vigorous and often aggressive exchanges between the bar and bench, which of course are now a thing of the past, and counsel's cross-examination. Apparently we are told that the public who had come to the entertainment of a court would boo and hiss, applaud their favourites, cheer and catcall. It was a very rough and tumble environment in which ladies or gentlemen of exalted status who would come to court would sit with the judge on his bench, and they would have a better vantage point to observe the proceedings, and they could ask the judge for points for direction in the course of the proceedings. So this is the environment in which Lord Blackburn was operating. The conditions of the courts themselves were also famously difficult. It was said that a Dr Angus Smith examined the air in the Court of Queen's Bench, where Justice Blackburn was later appointed. He collected and analysed perspiration gathered from the windows, and he concluded that the air was, I quote, the most deficient in oxygen of any inhabited place above ground. Returning then to the briefless Colin Blackburn of the Inner Temple, having in his own words, and I quote, literally nothing else to do, as I had then no business at all, he set himself to reading and writing. And he said this was more a means of teaching himself than in the hope of making anything of any value. The result was quite remarkable. It was a treatise published in 1845 under the title Treatise on the Effect of the Contract of Sale on the Legal Rights of Property and Possession in Goods, Wares and Merchandise. It seemed to become the standard work on the sale of goods. It was the only book on the sale of goods for about 20 years, until supplanted by Judah Benjamin's much more comprehensive work in 1868, a book that we now know as Benjamin's Sale of Goods. Now, there are some images from the title page of his book at the bottom of your handout, and there are large images out the front of the court today. The book, I think, was a remarkable achievement for a 32-year-old self-taught barrister. Blackburn later said towards the end of his life he took great pains with it. The introduction explained that the object of the treatise was to investigate how the legal interest in movable corporeal property is affected by a sale of it. It seems to me the book exhibited some of the characteristics that later came to characterise Blackburn's judgments on the bench. Firstly, when we pick up the book and open it, we notice how it progresses logically, very logically, from one proposition to the next, slowly and clearly. Secondly, the book focuses critically upon underlying principles and their relationship. It doesn't attempt to simply catalogue a mass of decided cases or focus upon points of procedure. Thirdly, and another point that comes through very strongly in his later judgments, and probably connected with the other two features we just mentioned, the author looks very much to civilian sources, particularly Poitiers, which he seems to have read in French. Blackburn does that in order to demonstrate the English and civilian rules for the passing of title to goods under a contract of sale are the same where there exist no differences of underlying principle, but are different when English and French law have some underlying difference of principle, and he makes the point that English judges had lost sight of this distinction. It seems to me, though, that it's difficult not to conclude that in selecting and exposing the underlying principles of English law, for example, whether there must be a delivery before title passes, which he examines, the author hasn't to some extent absorbed something of the intellectual architecture of the civilians. By that I mean the architecture that helps him to organise the subject. It's notable also that many of the cases that Lord Blackburn cites in this book were decided only in the last 50 years. Many were very more recent than that. And the volume of recent cases and the timing of the book itself, to my mind, was no accident. We're dealing here with a huge empire. The British Empire is getting towards its height, and the lifeblood of that empire was seaborne trade. So alongside charter parties and bills of lading for shipping, bills of exchange to secure payment and policy of insurance for risk, the contract for the sale of goods was a vital component of that trade. Domestically, of course, the industrialising of Britain that was going on had hugely increased the circulation of manufactured goods, and this was, of course, further bolstered by the advent of railways. The conditions outside the courts were ripe for many cases about sales of goods. And it seems to me also that Blackburn's book can be seen as an early precursor to the body of treatise writing that emerged as the 19th century progressed, and that seems to be an important part of a break from the past. a break from the past that gave rise to a new way of thinking about the law. To digress briefly, the earlier way of thinking about the law can be roughly described as follows. Knowledge of the common law consisted of knowledge of what forms of action could properly be relied upon, how the form of action should be drawn and then responded to in court, and of the very complex procedures attending the issuing and deployment of the particular form of action in court before a jury, or, if it was a question of law, before a judge alone. And the forms of action were, as we know, organised around the very old praecipe writs. They evolved from about the 12th century onwards, and by the 19th century, 600 years later, comprised very elaborate forms of action, reciting many formal matters that didn't reflect the truth at all. Rules of pleadings prevented you averring many facts that were true. Those matters that were merely fictional couldn't be traversed, and if you failed to use the proper form of action or to properly plead it, that would be fatal to your case. So the new way of thinking about private law that seemed to emerge in the 19th century, as we know, a long way down the track, went hand in hand with the destruction of these old forms of action. This was accomplished, as we know, by two very important Reform Acts, one in 1832 and one in 1852. The second act was associated with the work of two contemporaries of Lord Blackburn, the Irishman James Shaw Willis, a remarkable man, and an Englishman called George Bramwell. Each later became important judges alongside Blackburn. Willis was a Justice of the Common Pleas and Bramwell a Baron of the Exchequer. They were the three most powerful, intellectually powerful judges really at this time, as we'll see. So the new way of thinking that emerged during the 19th century saw private law coming to be classified not by reference to different forms of action, and so by reference to the alphabet, but instead by reference to claims in contract, tort, and quasi-contract, as it was then known, and perhaps between real and personal actions. So the common law moved from becoming a body of knowledge about what form of action could be brought and how they should be pleaded, to a more abstract concept of different categories of rights organised as rights arising in contract, tort, quasi-contract, or statute. We have this great move from procedure, as we would say today, to substance, looking at it through our modern eyes. And as scholars have emphasised, an important part of this great shift in thinking was the series of treatises that emerged during the 19th century of a kind that had never been seen before. So Blackburn's book that we're talking about now can, I think, be seen to form part of this new species of legal literature. We move then from Blackburn's book to his work as a reporter. Now, as we know, during the 19th century, both argument and reasons for judgment were delivered orally. Nothing was reduced to writing. And the practice of those in the business of reporting was to sit in court, watch, listen, and take notes. The notes could then be turned later into a printed report of the case. The modern system of authorised law reporting emerged only at the end of the 19th century. So before that time, all law reporting was undertaken by private publishers, and the resulting reports are, of course, known by the name of those who compiled them. And as we can imagine, in a world where the supply of barristers greatly exceeded the demand for their services, it's not surprising that in the early Victorian era, a number of ambitious young counsel took up law reporting as a way to earn some money, learn the law, and to attract attention from which some work might flow. Now, another Scot without family or other connections had recently done exactly that. That was John Campbell, who by dint of hard work and political skill had risen to become Chief Justice in 1850 and thence to the highest judicial office in the realm, that of Lord High Chancellor, in 1859. After gaining a start in the chambers of the celebrated special pleader Tidd, the ambitious and driven Campbell had reported on Nisi Price decisions of Lord Ellenborough. Campbell's private letters revealed that reporting was part of his strategy for personal advancement, in which his English detractors said that he had no equal. Campbell later became significant in Colin Blackburn's career, as we'll see in a moment. Now, for his part, between 1852 and 1859, Campbell collaborated with Thomas Flower Ellis, a barrister in Middle Temple, to produce reports on the decision of the Court of Queen's Bench and of the Exchequer Chamber in error. The identity of those courts becomes important. It said that Blackburn's habit was to sit at the back row of the old Court of Queen's Bench and listen. Manson observes that few ever thought that the young Scotsman who day by day seated himself in the back row of the old Court of Queen's Bench at Westminster was one day to become one of the greatest judicial lights of the 19th century. Now, it seems by the time of his reporting in the 1850s, Blackburn had developed a modest practice. Sergeant Ballantyne, his contemporary, says this, and I quote, Sergeant Ballantyne says this, "Latterly, before promoted to the bench, he was entrusted as junior with heavy mercantile causes, but never with the lead, and except amongst the solicitors who thus had experience of him, it could not be said that he had obtained reputation even as a lawyer." And Sir John Holmes, who wrote a book, again of his memoirs from a solicitor, tells a story about Lord Blackburn which reflects rather badly on his skill as an advocate before a jury. Now, a contemporary account written in The Economist upon his elevation to the bench said as follows, I quote, this is about 1859, he said, "Mr. Blackburn was a man unknown to fame. He was not great with a jury. No attorney would have chosen him to conduct a cause which required a large person, cunning advocacy, and humorous or ferocious eloquence. His circuit knew little of him, but there were places where he was known. Though he had a large and increasing practice of the most important and valuable kind in the City of London, he was better known to judges than juries." Now, we venture to say of Blackburn that in a difficult argument before the full court, he deservedly commanded the highest respect of every judge, and his service was eagerly sought for. And they said he's not only a sound, but a systematic lawyer. If anything, perhaps a little too much so, a little too hard and Scotch in his argument. And one sees of the contemporary accounts the continual reference to his being Scottish and what that was meant to imply. Now, in these circumstances, the odds were, with the practice he had, the lack of any connections of any kind, and the fact that he was largely unknown, the odds were that he would continue as quietly as he had, never taking silk and retiring as an unknown barrister at the end of the century. But as we've seen, the Chief Justice of the Queen's Bench between 1850 and 1859 was Lord Campbell, another Scot who also was a man of no connections of any kind. Ballantyne recorded that greatly are Lord Campbell's judgments indebted to Blackburn's clear and profound appreciation of the law. Ballantyne implies that it was the reporting by Blackburn which burnished the reputation of Lord Campbell. Now, we don't know, but through his workers' report at least, Blackburn must have become known to Campbell, and we may safely assume that Campbell knew also of their shared heritage of Scots of modest antecedents seeking success by dint of hard work in the class-conscious and highly competitive world of the English bar. Now, on the 18th of June 1859, Queen Victoria promoted Campbell from the office of Chief Justice of the Court of Queen's Bench, as we saw earlier, to Lord High Chancellor, even though he was then 79 years of age. It is suggested at the time that Alexander Cockburn, who we mentioned earlier, was in fact more eligible, but his colourful private life was of a kind that Queen Victoria was unimpressed with, and she thought that Lord Campbell would be more suitable. Now, we might pause to note that this month of June 1859 was an important one also for a far-flung corner of the empire, because a few weeks earlier, on the 6th of June 1859, Queen Victoria had issued letters patent creating a new colony in a place called Queensland. Now, later the same month, later in June, Lord Campbell exercised his new power to appoint puisne judges. At that point, the Lord Chancellor could appoint puisne judges. What had happened is that Earl had moved from the Court of Queen's Bench to become Chief Justice of the Common Pleas, replacing Sir Alexander Cockburn, who had moved to become Chief Justice of the Court of Queen's Bench when Campbell went up to become Lord Chancellor. This left a hole or a vacancy in the Court of Queen's Bench. Now, to understand the furore that erupted when Campbell appointed Colin Blackburn to the vacancy, it's necessary to say something of the realities attending the appointment of the Queen's judges at this time. And we must remember that there were far fewer judges at this time than there are now. The orthodox view was that those elevated to the high office of one of Her Majesty's judges would be a busy and successful practitioner who was well known to his circuit as well as being well known in Westminster Hall. If not a sergeant, the man would at least be a Queen's Counsel. An exception had been made for the Irishman Willers, who we mentioned earlier. He wore a stuff gown. But when appointed a Justice of the Common Pleas in 1855, Willis was well known and successful. He was also reputed to be the most learned man in the whole of England, having read, it was said, every law report from the yearbook onward, and having memorised many of the forms of action that we mentioned earlier. In addition, those appointed to judicial office at this time would very often have a seat in Parliament. And if they didn't, they would be very well connected with the government of the day. And indeed, there were no less than 75 lawyers in Parliament in 1853. It mattered not that the seats that they occupied were obtained by the bribery of the electors. Access to the House of Commons permitted a rising barrister to become known to the government of the day, to the Attorney General and Solicitor General, who could be expected to be appointed to the office of Lord Chief Justice and Chief Justice of the Common Pleas, respectively. They also have become known to the Lord Chancellor, who, as we saw, has the power to appoint judges. Now, by the standards of the day, what Lord Campbell should have done was to appoint a well-known Whig Queen's Counsel to fill the vacancy at the Court of Queen's Bench. And at the very least, he was expected to appoint a barrister who enjoyed a level of fame. Colin Blackburn satisfied none of these criteria. He had not taken silk. He had no special reputation as an advocate. Among the bar in London and in the Northern Circuit where he practised, he was largely unknown. Worst of all, perhaps, he had no seat in Parliament and seemed to have possessed no political connections at all. When it became known that Lord Campbell had appointed, of all people, an unknown Scotsman called Blackburn, there was an uproar. Four days after the appointment, the Law Times recorded as follows, and I quote, "Mr. Colin Blackburn is the new judge. The profession seems to know little of him, but that he is a member of the Northern Circuit and the Liverpool Sessions. On the face of it, the appointment is inexplicable." The bemusement ran to satire. Manson quotes the following commentary in the papers. This is what the papers are saying. "Everybody has been going around town asking his neighbour, 'Who is Mr. Colin Blackburn?' The very ushers in the courts shake their heads and tell you they never heard of such a party." Further discussion of the appointment in the press, the Law Times, is reproduced in the handout on the second page, and you'll see there the evident contemporary unease about the use of the power to appoint judges as a rewards for political service. And the author of that article commends Campbell for making an appointment without regard for politics. Now, Campbell's own diary, which has been recorded and is published, records for the 3rd of July as follows. He says this: "I have already got into great disgrace by disposing of my judicial patronage on the principle detur digniori. Having occasion for a new judge," he means merit, "to succeed Earl made Chief Justice of the Common Pleas, I appointed Blackburn, the fittest man in Westminster Hall, although wearing a stuff gown. Whereas, and this is interesting, whereas several Whigs Queen's Counsel MPs were considering which of them would be the man, not dreaming that they would all be passed over. They got me well abused in the Times and other newspapers, but Lyndhurst has defended me gallantly in the House of Lords." In the written paper, I've gone into more of the abuse that was heaped upon him, some of which is quite extraordinary. Lord Lyndhurst's defence that he mentions in the House of Lords was also reported in the papers. So Lyndhurst said this to the House of Lords, trying to quell the furore. Lord Lyndhurst said this: "I have been asked," I can't do the accent, "I've been asked, 'Who is Mr. Blackburn?' And a journal who takes us to task by turns has asked somewhat indignantly, 'Who is Mr. Blackburn? Who is Mr. Blackburn?' I take leave to answer, he's a very learned person, a very sound lawyer, an admirable arguer of a law case, and eminently fitted for a seat on the bench." Now, Lord Campbell is reported to have responded to Lord Lyndhurst in terms that reveal, I suggest, the unease that he must have felt that, in fact, this was nepotism on his part. He says this to the House of Lords, as reported in the press. This is Campbell. "I knew nothing of Mr. Blackburn, except what I knew from having seen him in practice in the court over which I presided." He says, "I have no private intimacy, and I declare on my word of honour, I don't know of which side he is in politics. but I have known him as a sound, good and able lawyer, one of the ablest in Westminster Hall. My only object was to appoint the person I thought would best discharge the duties of a judge in the Court of Queen's Bench. And Lord Campbell concluded his speech with words that turned out to be prescient. He said this: "I'm convinced that the more Mr. Justice Blackburn's qualities and abilities become known, the more will his appointment be approved." It was not long before the wisdom of Lord Campbell's choice became obvious to everybody. Blackburn quickly began to be known for his patience, carefulness and fairness. This, combined with his profound learning, caused the judge to become highly regarded by those who appeared before him. Sergeant Ballantyne wrote that there was no judge before whom he would have sooner practised. Only 9 years after his elevation, amidst the storm, the Law Journal was describing Mr. Justice Blackburn as one of the greatest judicial lights of the 19th century. A story was told about him soon after his elevation that is said to have attested to his scrupulousness in doing what he perceived to be his duty. It said that he was trying, not long after his elevation to the bench, an action in which damages were sought for an injury to the plaintiff, which had caused him the loss of an eye. The plaintiff's counsel dwelt forcibly upon the seriousness of the injury as blighting the plaintiff's whole future career. "I have lost the sight of an eye, Mr. X," said the judge, interposing, "and it has not blighted my career, as you see." The jury were much impressed by the judge's remark, it is said, and the damages they awarded as a consequence were trifling. Blackburn was conscience-stricken. He thought it over and the next day enclosed the plaintiff a cheque for £50. He went on to sit as a puisne judge for 17 years, initially as a judge of the Queen's Bench and then of the High Court following its creation in 1875. Now, of course, in 1876, the Appellate Jurisdiction Act reinforced the House of Lords with 2 judicial life peers, and the first to be appointed was none other than Colin Blackburn in 1876. He became the first Lord of Appeal in the Ordinary. In stark contrast with what had happened when he was appointed 17 years ago, the appointment was widely welcomed. And by this time, Lord Blackburn had come to be regarded as a glittering adornment to the court. His 17 years as a judge of first instance and his 10 years as a member of the House of Lords saw probably 2 cases that were regarded at the time as having importance above all others. Neither was one of the cases that every law student in England and Australia would read, and which we would today regard as the legacy of Lord Blackburn, cases like Smith and Hughes, Rylance and Fletcher, Taylor and Caldwell. Both of these decisions attracted public attention at the time, were, it seems to me, in a sense, a product of the fault lines through the British Empire at this time. Both cases and the events that gave rise to them were, however, largely forgotten today. I'll mention them briefly and then go on to the cases that he decided that are regarded as important today. The first of the cases that drew Lord Blackburn to the attention of the public and which were regarded as famous at the time was a trial in 1867 for Justice Blackburn and Mellor of the Manchester Fenians or Manchester Martyrs. These were Irishmen who'd been charged with the killing of an English police officer in September 1867 during the rescue of 2 prominent American Fenians who were being transported in a horse-drawn coach from the courthouse to jail. During the so-called rescue of these 2 men, an English policeman was shot and killed. Now, despite well-publicised doubts about the reliability of the testimony against the 3 Irishmen, they were convicted of the killing and subsequently hanged from the wall of Salford Jail on the morning of November 1867. The execution took place in front of a crowd of what was said to be 8,000 to 10,000 people, and after detachments of the 72nd Highlanders and the 8th Hussars had been deployed around the jail, supported by several thousand police. The trial and execution attracted enormous attention in England, Ireland and America, and occurred against a background of fear of imminent revolution against English rule in Ireland. Interestingly, the same dynamic was behind the second trial that Lord Blackburn became thrust into the public eye in respect of. Perhaps because of the strength of his performance in providing over this very famous trial of the Manchester Martyrs, Blackburn was soon presiding in a second matter of vital importance to the Victorian public and to the British Empire. This was the so-called Jamaica affair, another case that, as I say, seems to me to have arisen from the stresses and fault lines within the British Empire. I'll provide a very brief summary. After increasing tensions between black farmers and the minority white government in Jamaica, in October 1865, a crowd of black men and women, led by a black Baptist preacher, Paul Bogle, marched to the Morant Bay courthouse. When the crowd refused to disperse after the German chief magistrate had read the riot act, the local militia opened fire on the crowd. The crowd fell back, but then surged forward, setting fire to the courthouse. And when the occupants tried to flee, they were killed by the mob. Those killed included the chief magistrate and 17 other court officers and other persons, many of them, but not all of them, white. The man in charge of the colony of Jamaica at the time was Governor Eyre, and he declared martial law over the area of Morant Bay, and he quickly took control of it and the surrounding area with a small force of regular soldiers. What happened next prompted one of the most acute political controversies in the second half of 19th century Britain and gave rise to years of bitter litigation in England. After the apparent uprising had been suppressed, Governor Eyre convened a series of courts martial in the area that he had declared martial law over. Again and again, sentences of death were pronounced by military courts, followed by summary executions. Paul Bogle, the Baptist preacher, was hanged alongside with other alleged ringleaders, notwithstanding that many of them had not been there. In addition to those who were killed by these judicial executions, several hundred other black men and women were tortured and imprisoned without trial. In the weeks following the riot at the courthouse, it's thought that 439 black Jamaicans were killed and some 600 were flogged, often with extreme cruelty. All of the victims of this reign of terror were British subjects. When the government in London refused to prosecute Governor Eyre and the soldiers responsible, in December 1865, John Stuart Mill and other Liberals, supported by Christian activists, formed a committee for the purpose of raising money with a view to prosecuting Eyre and the military commanders for murder and other alleged crimes. They attempted to do this for the next 3 years. Now, the high point of the controversy as it affected Justice Blackburn came on the 8th of June 1868 at the commencement of a new session of the Court of Queen's Bench. So his lordship had been a judge for about 9 years at this point. In court was Chief Justice Coburn, who we spoke of earlier, Mr Justice Blackburn and Justice Mellor. Now, a rumour had spread through the bar and the court was packed. It was supposed to be the opening of a new session of the court. Now, those who filled the courthouse were not to be disappointed. Instead of attending to the business of the day, the Chief Justice began to make a prepared speech attacking the conduct of Justice Blackburn, his brother, in connection with Blackburn's direction to the grand jury delivered in the case of the Queen against Eyre 6 days earlier. In that direction to the grand jury, Blackburn had explained the law in terms supportive of Governor Eyre having a statutory immunity from his actions under the Jamaican legislation. This led to the grand jury dismissing the bill against Governor Eyre. The Chief Justice clearly thought this direction that Blackburn had given contradicted his own direction to a different grand jury, which had been impanelled to hear another charge instigated by the Jamaican Committee, this time not against Eyre but the military commanders Nelson and Brand. Blackburn was forced to sit in silence while he was publicly admonished by his Chief Justice. In particular, the Chief Justice told the court that Blackburn had been mistaken when he told the grand jury 6 days earlier that the other members of the Court of Queen's Bench agreed with the terms of the charge that had been pronounced. The Chief Justice went on, remarkably, to detail other errors in the terms of the charge that Blackburn had pronounced and attempted to demonstrate why it was wrong. Now, Blackburn attempted to defend himself, it is reported, by attempting to explain himself but the Chief Justice is said to have shaken his head and said, "No, you still don't understand." Afterwards, the Chief Justice wrote to another judge, Justice Lush, to obtain corroboration of his own version of events and published the letters to the press. Unsurprisingly, this behaviour caused an uproar. The Imperial Review described what had occurred as the greatest scandal that has arisen in the court since the trial of the 7 bishops. The event, in truth, marked another battleground, it seems to me, in the war that was being raged through the courts between Liberals on the other hand and Conservatives on the other, over the proper province of the rule of law in the British Empire. It does not seem, however, that any attention was paid at the time to the circumstance that Blackburn's own father had made his fortune in Jamaica, or how, if at all, that might have affected his assessment of the questions arising in the case as to the lawfulness of Governor Eyre's actions. Now, while these events were momentous at the time, they have since been consigned to history. They're a forgotten tale, alive for today's historians, but dead for its lawyers. It seems to me it tells us something about the development of our law, that when we note that the charge against Blackburn was followed by yet another piece of litigation that attracted much less attention for the Victorian public and politicians. This was a civil case brought by Alexander Phillips, a black British subject resident in Jamaica who sought £10,000 damages from Eyre and the military commanders Nelson and Brand. This action also was funded by the Jamaica Committee. The newspapers gave this much less attention. This was the very end of the affair. Now, in 1870, Phillips' successive appeals were finally dismissed. The judgment of the Court of Exchequer Chamber was given by Mr. Justice Willis, who we mentioned earlier. The case was reported as Phillips and Eyre. That name may be familiar to some of you. It has since become a key decision in the conflict of laws, and the rule that established is that for conduct in a foreign place to be actionable as taught in an English court, the conduct must be wrongful had it occurred in England and also not justified in the place where it occurred. I want to discuss a little more about this disjunction between the cases that were important at the time and those which seem to be important today. When we look at contemporary accounts of Lord Blackburn's decisions, we don't see any of the cases. We see very few of the cases that are now regarded as fundamental, and there are many lists that can be found of so-called important cases. And in contrast, if we look at contemporary texts, we can find many books devoted to decisions of Lord Blackburn. For example, one of the chapters of a book called Landmark Case in the Law of Restitution, published only in 2006, has a whole chapter devoted to the decision in Erlanger and New Sombrero Phosphate Company. Lord Blackburn wrote the leading decision, and it's now the leading statement of the principles concerning when rescission will be denied because restitute and integrum is impossible. 2 other decisions in which Blackburn played an important part are given a chapter each in another book called Landmark Case in the Law of Contract, published quite recently. Those cases are Taylor and Caldwell, to do with frustration, and Folks and Beer, concerned with consideration. And Catherine Macmillan's very good book, Mistake in Contract Law, contains a very long discussion of Justice Blackburn's decision in Kennedy and the Panama, New Zealand and Australian Royal Mail Company. Chapter 8, to go on, of the book Leading Cases of the Common Law is devoted to Rylance and Fletcher, for which Justice Blackburn wrote the key opinion. And of course, we know many textbooks and courts regularly cite Blackburn's opinions in cases like Tweddle and Atkinson on privity, Appleby and Myers on fixtures and entire agreements, Smith and Hughes on mistake, and many other cases. They're regarded as key or even canonical decisions in the private law. None of these at the time attracted any attention at all. Briefly, in terms of cases that really matter, Smith and Hughes perhaps was of particular importance because when Justice Blackburn held that whatever may be the case in the court of morals, there is no legal obligation on the vendor to inform the purchaser that he's under a mistake not induced by the act of the vendor. When he said that, he probably helped to foreclose the possibility that English law might come to recognise some general duty of good faith in contracting. Another very important decision of Lord Blackburn, I think, is Mackie and Dick, 1881, which provides the basis for the important modern rule that when something's to be done by one contracting party to enable the other to have the benefit of the agreement, there will ordinarily be implied into the agreement a promise that that thing will be done. It's the equivalent of Chief Justice Griffith's decision in Button MacDonald. Lord Blackburn's reasons in Scarf and Jardine continue to be relied upon by the High Court of Australia today about the law of election. His decision in Clough and the North and Western Railway Company is now a classic statement of the law governing the affirmation of voidable contracts, and we could produce more and more examples. None of these cases seem to have generated much interest at the time, and they're largely omitted from those lists I mentioned, contemporary lists of important cases that he was involved in. And it seems to me this observation, this disjunction, reveals a peculiar feature of the common law. The feature, and it's rather obvious, is that the relative importance of decisions to the long-term development of the law is very often unknown when the case is first heard and determined. What excites public attention or the attention of lawyers at the time may turn out to be of only fleeting importance. Now, this perspective of time allows us to try and understand one other question, which is this: why Lord Blackburn? Why Lord Blackburn as opposed to, for example, Sir Alexander Cockburn, Bramwell or Willis? Why have his decisions endured? And we should also recall that Cockburn and Bramwell were far more famous than Lord Blackburn as barristers, and Willis was said to have been the most learned man in England, the most learned lawyer in England at the time. I'll venture three observations as to why Blackburn, above all the others, has endured. Firstly, his work ethic is worth noticing. The early scholar and New York attorney Van Vechten Vida describes the volume of Blackburn's work as immense. He calculates that Lord Blackburn wrote the decision in about 600 pages in the reports, and of those, about a quarter of them, he wrote the unanimous judgment of the court. And he observes that in the whole of the 19th century, the only judge who came near to that output was Baron Park, who was in the first half of the century. Secondly, it seems to me there's his very logical mind and his clarity of expression, coupled with his obvious mastery of what the law was. And this was remarked at the time as being said of him, I quote, "Every conclusion is worked out with the hard-headed and closely knit logic of his race." But in addition to his work ethic, his logical rigour and his technical skill, it seems to me that what marked Blackburn out in his peculiar mastery of the law, and that explains why his decisions have endured, is his evident interest in trying to get at the law's underlying principles and his willingness to expound and develop those principles. Professor Cornish has said, and I quote, "His contribution was most telling when the issue was one of fundamental principle lying beneath the level of the evidently political." And Firefoot says that Blackburn and Willis were creative minds in a creative era. And that willingness to try and get at the underlying principle and state it and develop it is seen in many of the cases that are now regarded as fundamental. One sees it in Rylands and Fletcher, the principles of rescission in Norlanger's case, mistake in Kennedy's case, and frustration in Taylor and Caldwell. I think an argument could probably be made that Blackburn's interest in getting at and making sense of the law's underlying framework of principle is allied to his evident interest in civilian sources. That interest is very much on display in that book on sale that we were speaking of earlier, many pages of which we're looking at civilian sources. But civilian learning also comes through very strongly in many of his lordship's judgments. The most well-known is Kennedy and the Panama Steamship Company, where he cites Ulpian, but it's possible to see civilian learning in Taylor of Caldwell, Smith and Hughes and other cases which really have become of fundamental importance. It seems to me, though, that it would be an error to think that Colin Blackburn's contribution would have been similar had he been born in, say, 1713 or 1913, and that really it's just the fact that he was a man of particular genius that explains his enduring quality. It seems to me, with the benefit of hindsight, Blackburn's timing was of critical importance. We've already noticed that 7 years before his appointment, the old forms of actions were swept away by the Reform Acts of 1852, and that this paved the way for new ways of thinking. And of course, at the other end of his career, he was sitting when the judicial reforms came in, reforming the courts and infusing administration of law and equity. Side by side with these institutional changes, there were obviously other important developments that helped to explain why the 19th century, and particularly the second half, was so important. We can think of a number of things. The companies legislation upon which all British and Australian Companies Acts are now based was enacted in 1862. there was the vast private wealth that was generated by an empire settled, which centred in London, and that, combined with the companies legislation, generated vast amounts of litigation in the 1860s and 70s involving companies. There was the advent of the railways from the late 1830s, huge investments in canals, dams, sewage and other public and private infrastructure, often pursuant to private bill legislation, and other waves of economic activity. All of this external change outside the courts generated the conditions for large amounts of litigation that had never been seen before and raised legal problems of a kind that were entirely novel. Now, after 17 years as a judge of the Queen's Bench in the High Court and 10 years in the House of Lords, Blackburn retired as a judge in 1886. He was 73. Now, at that time, judges were appointed for life, and there was no requirement for him to retire when he did. Many judges worked long after the age of 73, and a number died, as it was said, in harness, Lord Campbell being one. The Law Journal at the time observed that he retired owing to the state of his health, and Manson said, and I quote, "He retired a victim to the sad disease which often attacks the strongest of brains. Precisely what his illness was remains unclear." In a letter from Pollock to Holmes many years later, Pollock reports that when retiring, Blackburn said, "Damn the law," and read nothing but French novels. Whether that's true, we don't know, nor do we know how Colin Blackburn spent his remaining 10 years. He never married. Presumably his final years were indeed spent reading French novels up at Doonholme, a mansion house that he'd purchased in the middle of the 1800s, and which, like his childhood home, sat near the banks of a Scottish river, in this case the River Doon in rural Ayrshire. At the very end of the century, on the 8th of January 1896, Colin Blackburn died at Doonholme. The obituaries that flowed were effusive. The Harvard Law Review stated, "The greatest English common law judge of recent years has died," before stating that Blackburn's judicial opinions rank among the very best of the time. Soon after his death, Manson's book on judges of the Victorian era said, at the time of his retirement, Lord Blackburn was unquestionably esteemed, the beautiful Victorian language, unquestionably esteemed the highest exponent of the principles of our common law, which he is said to have provided luminous exposition. And that we're here tonight in Queensland reflecting on Lord Blackburn's life and work 119 years after his passing near the quiet banks of the River Doon, far away in rural Scotland, seems to me the least testament to a remarkable mind and to a remarkable man. Thank you.
It's my pleasure now to formally thank Dr O'Sullivan for his paper. It's my pleasure not merely because the paper reveals a Scot prevailing despite Sassenach prejudice, but because the paper, as I said, which you've heard much of in that speech, draws together the strands of a life which touched not only legal scholarship and personality of the subject, but also draw together the relevant influences of government, empire, politics and society at the time. The paper itself will be published together with a video on the library's website and on YouTube. I think there are some copies likely to be outside, and you will agree, I'm sure, from what you've already heard, that it is a work of scholarship. Can I just mention a couple of things which Dominic has encouraged me to mention. The first is on the question whether Lord Campbell, another successful Scot, really showed some undue favouritism in appointing Blackburn. In Charles Kingston's famous Judges and Famous Trials, Lord Campbell is said to have thought highly of his friend's abilities. If accurate, it may suggest that it wasn't just scholarship that got him the job. Also, in the same book, there's an interesting description. There's quite a few descriptions of Blackburn around. You heard one of them earlier. This is different but equally interesting. He's said to have had a strong face and a determined expression, a harsh voice that revealed his Scottish birth, a nervous horror of female witnesses, and a half-ironic consciousness of the intellectual inferiority of the barristers who practiced before him. None of this is similar to anything that we see today, of course. Also, it may be that those qualities didn't endear him to some of his fellow judges. In a book called Jottings of an Old Solicitor, published in 1906, Sir John Holmes attributes some words to Lord Bramwell. It is said that Lord Bramwell was fond of describing a conversation which took place between him and Blackburn with reference to the dinner to be given in honour of Bramwell's retirement. Lord Bramwell was not only an eminent judge, but he was a popular one. Lord Blackburn was also an eminent judge, but it is said he was not universally popular. Lord Bramwell said that on the day of the dinner he happened to meet Lord Blackburn. He, that's Lord Blackburn, said, "I'm not coming to your dinner, Bramwell." Lord Bramwell said, "I did not suppose you were." Blackburn said, "No, I do not like such things. When I retire, I shall do so on vacation." Lord Bramwell responded, "My dear Blackburn, it will be a very unnecessary precaution." We are indebted to Dr O'Sullivan for his paper, and I will ask you again to thank him in the usual way. And like a rabbit out of a hat, I should also mention that the upcoming events include, importantly, the Supreme Court oration on the 29th of this month at 5:15 p.m. here, which will be presented by the Right Honourable the Lord Judge, Magna Carta, Destiny or Accident, and also another treat in store on Thursday the 15th of October, another Selden Society paper, in this case the Honourable Justice Peter Applegarth on Lord Atkin. Now you're all invited to enjoy refreshments in the foyer. Thank you.